Before we get started, head on over to Instagram and look for the giveaway I posted from Like Mother, Like Murder. You have a chance to win a $100 Amazon gift card, a Starbucks and Target gift card, and a ton of cool podcast merch, and all the details are in my Instagram stories and posts. This effort is to help support a fellow podcaster from the One Nothing podcast. Amanda is an amazing human, and she's just had life deal her multiple blows back to back, including 2 hurricanes. If you can't find the post, send me a message and I'll send you the details. But you can get a lot of cool merch, including stickers from us, and other shows have donated too, including the Hot Garbage Show, Like Mother, Like Murder, Curiosity Killed the Caves, Beyond the Shadows, Down the Rabbit Hole, The Haunted and the Strange, Caffeine Crimes and Canines, Where the Weird Ones Are, and Primetime Crime. You must enter by October 26th, and the winner will be announced live on Instagram October 27th, 2024. So don't forget, go do that. Guilty. I knew before I listened to the jury verdict that David Michael Crawford was found guilty. However, hearing the jury foreperson repeat the word guilty 12 times in an otherwise silent courtroom elicited feelings that are hard to describe. The word feels so final, substantial, and weighty as it echoes through the halls of justice. And I'm sure with each repeat of the word, Mr. Crawford felt something too, but I can only hazard a guess as to what those feelings might be. Did he feel anger? Sadness? Perhaps fear? These are all emotions that his victims have come to know very well. It's impossible to say for sure how he felt, but I do not have to hazard a guess about the weight of those words for the victims, because some of them talked to the press to express their feelings. For his victims, that 12 times repeated word lifted weights off their hearts and minds with every single repetition. David Michael Crawford, the man that had made them into victims and stole their sense of security, was found guilty of 8 counts of attempted first-degree murder, 3 counts of arson in the first degree, and 1 count of first-degree malicious burning. David Crawford has been many things in his life. He was a public servant, a police officer for over 30 years, and he was a police chief. And now he was a convicted felon times 12. David Michael Crawford, a septuagenarian, is a convicted serial arsonist. This is the finale of the David Michael Crawford serial arson case on Crime to Burn. Welcome to Crime to Burn, where we explore the dark city landscape where true crime intersects with arson and criminal negligence. Join us as we sift through the ashes to bring you the story of what really happened. Welcome back to Crime to Burn. I'm April, a fire protection engineer and former firefighter.
And I'm a Jedi master of awkward silences.
I'm just soaking up the subsequent awkward silence. The mastery. Okay.
This is not the silence you're looking for.
A quick reminder to please be sure to leave us a 5-star rating wherever you listen to us. If you have not had a chance to leave us a rating, we sure would be appreciative if you would do that. Be sure to subscribe to us on our YouTube channel, follow us on X, Facebook, and Instagram, and if you have a fire story, information about this case, or a case suggestion, or any constructive feedback for the podcast, please reach out to us at crimetoburn@gmail.com. Without further ado, updates. We have them. First, I am still awaiting the investigation and incident reports from the PG County Fire Department for some of the other fires in Laurel that I am looking into. And I'm still hoping that somebody from Anne Arundel County will be brave enough to give me an off-the-record account of whether or not investigators were told to stop looking at Crawford in the cases of harassment against Carrie, his daughter. I'm also hoping somebody has some information about some sort of former police department employee that maybe had some sort of maternity leave issue with Crawford and then a subsequent fire of some kind. This may have been either in PG County or when he was with District Heights. And I'm still looking for information on a boat fire that may have resulted from some sort of skirmish with somebody that he worked with at one point. I did hear that the boat fire may have occurred in Pennsylvania, but it would have been while he worked at either PG County or District Heights. So if you have any information, please reach out. You can stay off the record. I will keep you anonymous. If you worked with Crawford or know somebody that did that has knowledge of any of these incidents, even if it's secondhand, but maybe you can provide me with a name or maybe just enough additional information to give me something else to cling on to investigate, that would be great. crimetoburn@gmail.com. And even if you aren't sure if you can offer me information that's in addition to what I already have, I'd still like the opportunity to hear from you and maybe talk to you. It's my job to sort out what's usable and what isn't, so you don't need to worry about that. But I can't make the determination about what knowledge you might have, whether or not it's going to be valuable, without hearing the knowledge. So even if it's just rumor, but it may align with some of the rumors that I've heard, I would really love to hear from you. Now for the updates that I do have in this case. I have been complaining that we did not get responses from Prince George's County for Crawford's disciplinary and complaint records. And I initially reached out to Prince George's County, and they sent me back an email with a form and told me how to fill out the form and to send it back. And that's what I did. And then they went radio silent despite multiple follow-up emails. But then somebody sent me a website and said, have you tried submitting it through this website? And I had not. So I submitted it through the website, and I did get a response. Ironically, the response came from the same person that I emailed the initial request to. But this time he said, hey, by the way, we got your request. And because it's covering such a long period of time, since Crawford worked for them for so long, he's going to need more than 30 days to respond. And by law, he's required to let me know if they need more than 30 days to respond. And it didn't say, great, but what about the 6 months since the last time I requested it? I just said, okay, thank you. If you could keep me updated, I'd appreciate it.
You catch more flies with honey, don't you?
I kind of wanted to be angry, but I was like...
Held your Karen in.
I held my Karen in. All right, and I still haven't heard back from District Heights. I don't know that I ever will, but hopefully. So last week, we ran through all the fires in order and what evidence the prosecution presented, and then we talked about the defense strategy and closing arguments. And one of the things we spent a little bit of time talking about was the elements required to charge Crawford, along with what the state's burden of proof was to prove that he was guilty beyond a reasonable doubt. And we talked about specifically a bit about first-degree attempted murder. And I mentioned that I thought that in the Henderson case, he did intend to commit murder. However, I did hear from an attorney this week. Thank you so very much. And he offered a different perspective that I felt was worth sharing with everybody to see what you think. He pointed out that Crawford was trying to reduce the chances that he got caught by committing arsons across several different counties, some cars, some garages, and he may have done this specifically to reduce the chances that he got caught, because we know that it can be difficult to investigate crimes across jurisdictions that might have helped them identify a link between these sooner. And even if he did get caught, if he got caught for a fire in one county, but they weren't able to tie him to one in another county definitively, his charges might have been less or more lenient. So this person thought that in that vein, he thinks Crawford was intentionally setting garages and cars on fire because he was trying to keep all of these fires from becoming a murder investigation, which would increase the press coverage, the investigation of the fires, and would probably spur investigators to look across county lines for other crimes of similar MO. And so he thought that Crawford, while he did exhibit a wanton disregard and recklessness and sort of a, oh well, if somebody dies, he didn't think that he was actually intending to commit first-degree murder. And I can see that perspective, particularly in the earlier fires. So the way, I don't know if I went into great detail about this, but the way that he was caught actually was after the Rich McLaughlin fire, which is one of the last fires. I think there's one or two after him, I'll tell you for sure in a second. But after that fire, investigators sent out the video from that fire to all of the neighboring counties to try to drum up any other leads. And that was when Montgomery County was like, whoa, we know that guy. We've been dealing with the same guy, I think. And so once they identified that he was active in two counties, they put together a multi-county task force to look for other fires with similar MOs and collect the evidence and compare them and try to tie him to the other fires.
They're getting better at working together.
So it was just because that one investigator was like, I'm just going to take a chance and send this video out to see if anyone responds.
That's good. That was clever. He should get a Smecker Award or something.
I don't know what that is.
Can we give out Smecker Awards?
What's a Smecker Award?
The investigator from Boondock Saints.
Oh.
Put the earphones on, or the headphones on, and danced around the crime scene figuring out what happened.
I gotta watch Boondock Saints again. You keep talking about it, and I keep not remembering.
Smecker Award.
All right, we'll put together some Smecker Awards. And so I do understand what this attorney is explaining, that why he doesn't think he was attempting to commit murder. However, I can also say that when we consider serial criminals, not just serial arsonists, but serial killers too, we often see escalation. They start out being more cautious, and as they get used to that sort of sick thrill of what they've done and the fact that they've gotten away with it, they tend to go on to seek bigger thrills, and their confidence gets more stout, and they start to think that nobody can ever catch them, and so they take more risks. And I look at these fires and I have to ask, does this fit a pattern of escalation? So let's talk about this for a second. We've got the Marty Fleming fire, which is the one where he set the cars on fire as well as his own pants and his own shoe, which, let's give him the benefit of the doubt and assume that was accidental.
It may have been accidental, but it was still hilarious.
And then after that, we have the first fire at Justin Sherstrom's home, which occurred when no one was home. And then we have the Erica Byrne fire, which was another car fire. And then we have the Antico fire. So this was the first fire where he set the garage that was attached to the house on fire. The way the house was set up was you had the garage and then it was attached to the house, but there was no living space above the garage. It was sort of house garage glued together.
Arthur Fonzarelli wouldn't have stayed there.
Probably not. And then we have Justin and Miriam's second fire. And at this point, that house was vacant. Then we have Evelyn and Scott's fire. So this is the fire where the family's home asleep. The house has an attached garage, but it's a one-story house. So the garage is on one end, bedrooms are on the other end. Then we have the Bud Price fire. Again, home asleep, garage lit on fire. And then we have the second Henderson fire, which occurred while the house was unoccupied. Now, I think we can drop this one out of our question of whether or not they're escalating, because I think this was really an extension of the first fire. He was trying to prolong that sick joy that he got from what he did. And in this fire, he set fire to the front door instead of the garage. And I have to wonder if this was an experiment to see how the results would be different, how much more damage the house would incur, how fast it would become untenable.
He left a lot of information about, references to what he did. He didn't happen to take notes about getting better at it, did he?
Not that was introduced in court. After that, we have the Hawkins fire. And the Hawkins fire was, again, the truck was lit on fire, but the truck was backed up to the house. And he lit the fire in the tail, in the bed of the truck.
Fire right in the tail.
He lit the fire right in the tail. It was in the bed of the truck, and the truck was backed up to the house, and it was a townhouse. So this would have been directly below the area where the family was living. And then after that, we have the McLaughlin fire. And while the McLaughlin fire was a detached garage, the garage was not detached from the house by much. The garage sat here, and the exterior wall of the house was sort of at a 90-degree angle to the garage. And this fire was so intense that it broke the windows in the exterior wall of the house and impinged on the house. So this one, it did spread to the house. And this wall that it was up against was the bedroom wall of the house.
Turn that house into a Dakota stove.
Yes. And then we have the last fire, which was his nephew, Scott Crawford, with the pool. And so if we talk about this from an escalation standpoint, we see some back and forth. But I want to suggest that if we look at all the fires without looking at any of the family members' fires, because I do think that he had reason for restraint when he was targeting his family. He was friends with Scott Crawford's mother. Reportedly, he and Mary were very close to them, which is what caused their initial falling out. And so I don't think he would have wanted to do something that would have hurt this woman that he considered his friend. So I think that was the reason why he targeted the pool and not the house in the Scott Crawford fire. And when we look at the Justin and Miriam Sherstrom fires, that's Mary's son and their grandchildren. So I don't think he was intending to hurt anyone in those fires.
He may be a real jerk, but, endeavoring to light a pool on fire is fairly ambitious, in my opinion.
Yeah, it is. So I think if we assume that he had reason for restraint in the family fires, then we do definitely see an escalation pattern. We see car, garage that doesn't have living space above it, house where the family's asleep. The garage is at one end, the family's at the other end of the building. And then we see another garage while the family's asleep. And then we see the second Henderson fire, which is lit at the front door. And then the Hawkins fire, the bed of the truck backed up to the house. Again, living quarters directly above the garage because it was a townhouse. And then the McLaughlin fire where the fire did impinge on the house. And so I do think that might illustrate an escalation pattern to me. I bring that up because while I understand what the attorney that reached out to me is saying, that he thought Crawford wasn't intending to commit first-degree murder, he just didn't care if he did, I think Crawford was actually escalating. And I do think that the thought was there that he could kill people and get away with it. And that was exciting to him.
I don't know. I have kind of a different theory, I guess.
What's your theory?
Well, it's not that much fun to watch people suffer if they're dead.
Oh, that's a good point, too.
So I don't know. I don't know if he's an attempted murderer, but he sure is a son of a bitch.
Yeah, I'll agree with that. I want to know what our listeners think. So reach out on Instagram, X, or Facebook and tell me, do you think this is an escalation pattern? And do you think that he actually intended to kill anyone in either the Antico or Henderson fires, where he was charged and found guilty of first-degree attempted murder? Now, the same attorney also told me that he thought that we see evidence of his restraint and trying to keep it from being a murder investigation when we look at Carrie's harassment also. Specifically, the two of the shootings he shot into the gyms one where Carrie worked, one where he thought Carrie worked, while the gyms were closed. And it's possible that he didn't know that the cleaning crew was there in the one case and the other building was empty. But my response to that is that he also fired into the house where Carrie and her mom and stepdad were living while they were asleep. So I'm not sure that he was really trying to avoid murder, or if it was just a factor of he's less likely to get caught late in the evening when everyone's asleep than he is if he tries to go shoot up a gym while people are working.
I guess, but I still think it was those York boys. I'm a little afraid of them still.
Okay. All right, and finally, while this attorney that reached out to me isn't a criminal defense attorney, he did offer me some more legally sound reasoning than I can proffer for the motion to acquit. He explained to me that when the judge rules on a motion to acquit, he often offers in his denial of the motion his reasons for denying it. And in those reasons, he may reveal, inadvertently or advertently, areas that he perceives the state's case to be weak, and that this can help the defense attorney capitalize on those perceived weaknesses that maybe the jury also picked up on in his defense efforts and in his closing arguments. So, in addition, that motion to acquit is part of the official court record. And so the issues that the defense takes with the court's decisions that might be grounds for appeal are better documented if they're also brought up in that motion to acquit, because you cannot make a motion you can't make an appeal on errors the court made that you didn't disagree with during the case. So, you can't sit there and not object to anything and then file an appeal and say, the court did this wrong, this wrong, this wrong, and this wrong. You have to actually bring it up. The defense has to object, and then they can use that as a basis for appeal. Their issues with the case have to be documented. So, by including them in the motion to acquit, they have that documentation that the defense attorney took issue with decisions the court made.
Sounds all very simple, like I before E except after C. I get it.
Okay. The prosecution's case is based on the hit list, the research he did on the victims, the strained relationships, the ties that each of them had to the defendant, and we discussed the closing arguments of the defense in depth last week. But there's one closing argument of the prosecution that I want to bring up. Now, in court, the procedure is that the prosecution, they rest after they presented all their witnesses and everything, and then the defense has the opportunity to present their case, which we know that Bonsip only introduced a piece of evidence and a stipulation in defense. And then the prosecution offers their closing arguments, and this is their opportunity to take everything they presented and tie it up into a little bow and create that beautiful narrative that the jury can follow easily. And they tell the jury what they should decide based on the case that they presented. And then the defense gets to get up and rebut all of that and give his own version of the facts of the case and why he thinks that the defendant is innocent or shouldn't be found guilty. And then after that, the prosecution actually has a chance to rebut the defense's closing argument.
I love getting rebutted by the prosecution. Right. What did I say?
You know what you said. So the prosecution did choose to rebut after Bonsip's closing statement. And there's 2 points that they made that I thought were interesting. They said that in any case of murder, the one thing we know is that the motives are almost always silly and inane to us. And it doesn't matter what we think of the motive. What matters is what was in the heart of the defendant at the time. Now, Bonsip had argued that the motive for murder was weak, that some of these people couldn't even remember their disagreements, couldn't name something, or had a disagreement more than 20 years ago. But the prosecution came back and said, we've heard about road rage killings. We've heard about killings of people that just flew off the handle about being insulted over, very small sums of money. So the motive, how serious the motive is, isn't evidence. If there's a potential strained relationship there, that can be enough motive.
Yeah, but like in the case of road rage, I don't think people who road rage necessarily want to kill each other. I think they just want to inflict some kind of suffering on the other person to a degree that they perceive is appropriate to whatever damage was done to them that they thought, right?
Mm-hmm.
Like, however they thought of that. There's a way that they weigh that and measure it, and they decide, well, this could be enough suffering. This might satisfy me, and this will make me feel better about whatever happened, even if it wasn't real.
Right. And so that's more like a crime of passion, and I would agree with you on that. But we have seen people that have intentionally committed first-degree murder over insane...
I'm not saying that doesn't happen. I'm saying this guy doesn't appear to fit that sort of a profile, in my opinion.
In my opinion, I think that in Crawford's mind, there was absolutely motive. I don't think any of these were unjustifiable to his twisted way of thinking. I think anything that insulted him needed to be wiped off the face of the earth, in his opinion, or at least made to suffer.
Well, I'm not even saying that makes it less atrocious or anything like that. That's not even what I'm saying. Sometimes there's things you can suffer in life that, you just probably might not, had you not experienced, maybe your whole life would have been better had it been shorter. I don't know. So
what the defense is saying, though, is that, look, the prosecution didn't even give you a real motive. And the prosecution's saying, we don't have to give you a real motive. Like, we've seen people commit murder for things we will never understand. We don't have to understand his motive to look at the evidence and make a decision.
Yeah. But I think it's important for them to consider all that. Consider that he just seems like the kind of person that wants to watch you hurt.
I agree. That is exactly what he seems like. And the second thing that they brought up, which I thought was really interesting, is they told the jury, think about all the people you know that have had fires. This guy knows 9 families that have had fires. Do you know 9 families that have had fires? And if you do, or even if you know more than one that have had fires, how many of them were actually determined to be arson? So basically he's saying, statistically speaking, the fact that this guy knows all these people that have had fires and all these people that have had arsons is statistically highly improbable, if not impossible. So...
But does that allow for the fact that he's a police chief and knows a lot of things, like knows the community better than probably a lot of people? Think about your local sheriff or somebody like that.
Uh-huh.
They're tied to a lot more people than the average dude.
That's what I thought about. So I'm a former firefighter, and I thought, all right, how many people do I know that are friends or acquaintances, not I knew because I responded to a fire at their house, that I know that have had fires? And I came up with 6, which is probably a lot.
I've got probably a similar number to that.
Okay.
But none of them that I know of are arson.
That's what I was going to say. None of them were arson. Now, without going into specifics on all of them, some were electrical, some were accidental. I know one for sure was lightning. But 0 of them were determined to be arson.
Yeah.
So I thought that was an interesting thought game. But I will say, I am kind of an introvert and a recluse, and I don't... maybe you're right. Maybe somebody that has more contact with the community would know more people. But I will tell you, there's actually at least 10 families he knows that have had fires. And I'll get to that before we wrap this episode up.
And they all pissed him off in some way?
Possibly. So after the prosecution's rebuttal, the jury is sent off to go deliberate. And they deliberated for the second half of the first deliberation day, because the morning half was closing arguments. So they get to the second half of the day, they deliberate, they leave to go home for the night, they come back the next day, and sometime during the second day of deliberations, they come back and send the judge a note and say, we have come to a unanimous decision. So David Crawford was found guilty of every single charge in Howard County that he was charged with. So that was 8 counts of attempted first-degree murder, 3 counts of first-degree arson, and 1 count of first-degree malicious burning. Now, the jury does not get to decide punishment, but the same judge that presided over the case did determine sentencing. I think this case wrapped in, if I remember correctly, in March, and sentencing was in July, I think, the end of July. So the same judge presided over it, and remember, at the time of sentencing, David Crawford was 71 years old, and he was sentenced to 8 life sentences plus 75 years.
The judge smelled something on that, didn't he?
So some of those sentences were set to run concurrently. So the executable sentence was 2 life sentences plus 75 years. And I don't know if he was sentenced to life with parole or without parole, and it doesn't really matter because he's 71, so he's never going to get out. But if he was sentenced to life with parole, he still would have had to serve 20 years of each of those sentences, plus the 71 years meant that he would be 111 years that he has to serve before he's eligible for parole. So unless he has some Methuselah DNA and lives to be 182, he's spending the rest of his life in prison. And we know he already had 1 heart attack, so I don't think his chances of making it to 182 are very good.
How old is he now?
He was 71 at the time of sentencing, so I think he's 72 now? 72. One thing that I noted from a press article that I found really interesting, because I did not get the court recordings from sentencing, and I wish I had in hindsight, but man, y'all, court recordings are so expensive. Anyway, but one thing that I did find interesting was the judge, when he sentenced Crawford, he specifically criticized Crawford on the fact that his car had that Sure Can license plate. And that he took issue with the defendant sort of secretly flaunting an inside joke about his criminal arson spree.
Oh, I didn't even think about that.
Yeah. Now, Crawford did speak at his sentencing, and I don't have all of, like I said, I don't have all the court recordings, but I know that he did not express remorse or apologize to anybody. And that doesn't really surprise me because he did appeal. But he also mentioned God. And
what did he say about God?
I don't remember, but I can find it for you real quick.
I'll get a beer while you look that up.
All right.
And I want to thank God for this Arson award.
No, that's not what he said. Crawford was given the chance to speak before sentencing, and he talked about his renewed faith in God during the past few years in jail. And he said, with God, all things are possible.
Amen, brother. Amen. And I'm glad that he has renewed faith in God, and I'm glad that he has salvation from the Most High.
I am also glad.
But I'm afraid the great state of Maryland is going to be a little more hard-nosed.
They are. The attorney for Crawford, as we know, has filed an appeal on his behalf, and that appeal is currently pending in the Maryland Appellate Court. So we're going to go through the grounds for the appeal, and in the interest of not boring everyone with incessant case law, and in the interest of not looking like a moron, because as I have mentioned a few times, I am not a lawyer. Please forgive me if I get something wrong, but feel free to reach out at crimetoburn@gmail.com. But we're just going to give like a high-level overview of the appeal. Maybe after the appeal settled, Mr. Bonsib would be willing to come and talk to us about case law specific to these grounds for appeal. My email address is crimetoburn@gmail.com. So the first issue Mr. Bonsib presents is the inclusion of the evidence of the uncharged fires at trial. So I'm going to read you what the argument exactly reads from the appeal document. The trial court abused its discretion by failing to limit the number of the 8 additional other fire acts admitted in an arson trial that already joined 4 separate fires. They then present, in the next sentence in the appeal document, the Maryland rule related to admitting other acts. And here's what it says. Evidence of other crimes, wrongs, or acts is not admissible to prove the character of the person in order to whom action in conformity therewith. It may, however, be admissible for other purposes, such as proof of motive, opportunity, intent, preparation, common scheme or plan, knowledge, identity, or absence of mistake or accident. I feel like the answer is right there in the law. Proof for common scheme. The target list loses its value as a piece of evidence without that proof of a common scheme, and you can't prove the common scheme without admitting the other fires. So I feel like the evidence that was on his computer, which included all of the research, and the 2 additional names, Josh Gates and Mark Kratzer, and we see that there's evidence that the defendant was also researching them, I feel like that shows proof of a common scheme. But Bonsip says that including all 8 of the additional fires is too prejudicial and outweighs the probative value. Now, as I understand it, to be granted a new trial, it's not enough just to say that the court erred. The court had to have erred, and the error has to have been substantial enough to have impacted the outcome of the case, meaning that the jury might have decided differently if the error hadn't have occurred. So let's say that the court case only was allowed to focus on the 4 Howard County fires. We know that he did research on the victims. We have the highly debatable and circumstantial motives. We have calendar entries for the Henderson fire. And we have the Apple Health data showing that at the times of many of the fires, he was awake before and after. And a little side quest. I didn't mention this, but the lawyer that contacted me mentioned that to him, the Apple Health data was some of the strongest evidence, and I didn't actually even bring it up in my last episode. And the reason I didn't was because I didn't feel like the prosecution did a good enough job of showing that the activity for him at those hours was unusual compared to just his normal waking and sleeping cycle.
He's not just like a night owl. He like set an alarm or something, maybe.
Maybe, but that's the thing, is that they only presented the Apple Health data for the days of the fire. They didn't say, look, here's the month that this fire occurred, and there's only 3 days or whatever that he was up at these hours.
That's what I was asking.
Yeah, they didn't present that. So to me, it wasn't strong enough. It could have been stronger.
Yeah.
Anyway, that was a little bit of a side quest, but I wanted the prosecution to give me more substance with the Apple Health data. But I still think that even if we didn't see all the other 8 fires, that even with all the circumstantial evidence, and even without that list, we have a pretty strong case. Still, in my mind. Is it strong enough for 8 attempted murders? That's a really tough call to make. To me, the nail in the coffin is the list. And I think if they had just presented the list and only told us about the evidence related to the 4 fires in Howard County, if I was on the jury, I would have wanted more information about the list. Who are all these other people on the list? Why are they on the list? Maybe this is a list of people he was going to invite to his birthday party. Like, I would have needed that extra information to make the list make sense.
Isn't it funny what your mind will kind of get accustomed to? Because I imagine there are some people in the world that get convicted for setting one fire, right? Like, just one. Through the course of the last 9-10 weeks, wherever we've been recording this for, you start to lose sight of that. You start, it's only 2 or 3 fires. Well, that's fine, right? I mean, everyone.
No, I didn't say it was
everyone
fine.
Gets to take a mulligan on 2 or 3 arsons. It's cool.
No, that's not what I'm saying. What I'm saying is, was the evidence specifically in the Howard County cases strong enough to get a first-degree attempted murder conviction without seeing the pattern that was introduced with all of the fires?
I think that would just make it worse, trying to get an attempted murder out of that many unsuccessful murders.
Okay.
Well, right? If you're trying to do it and you did it that many times and you were not successful once, you either sucked super hard or you just weren't trying to do that. I'm not trying to play defense attorney again. It just doesn't make sense.
Okay.
Maybe he just sucks that bad at fire.
Maybe he does. All right, in my mind, as a not legal expert, I think that the court did the right thing by allowing the other 8 fires in, because I think that they explain the list on the phone and they illustrate a common scheme, and the law specifically allows for a common scheme. And I kind of want to be like, exactly whose fault is it anyway that there's prejudicial information that got included? You're the one that put an entire list in your phone.
And PowerPoint.
And PowerPoints. So this raises, again, like I said, the question of if it wasn't for the list, if it wasn't for the other 8 fires to be admissible, would the jury have found differently? I can't say. But I don't think that the court erred. So, in my mind, I think this is not going to be a successful argument for grounds for appeal. But again, I'm a legal idiot. So feel free to disagree with me, crimetopburn@gmail.com.
But you're also legally sexy.
Thank you. Okay, so before we move on to the second grounds for appeal, I wanted to bring up one interesting point. One thing a juror said during voir dire was actually used as part of the supporting evidence that these other 8 cases were too prejudicial. The jury candidate said something along the lines of, "Why are we even here? There's so much evidence here. Of course people think he's guilty." And the defense used this guy's statement in their appeal, which I found fascinating, that a jury candidate that wasn't even seated as a juror thought the evidence was so overly prejudicial that he was like, why are we here? This is stupid. And here's the direct quote that was included in the part of the direct quote that was included in the appeal. This is what the guy said. And I'm not being disrespectful. Maybe something's like wrong with whomever it is, but it doesn't sound like coincidence, and coincidence. That doesn't even make sense to me.
Well, that guy told the truth.
So, I agree. Maybe something is wrong with a guy that is accused of committing 12 arsons across 6 counties and after wrapping up a 30-year police career. Now, there are more arguments. Maryland law establishes the requirement that in a case involving multiple instances of other bad act evidence, the court has to consider whether to limit the number. But in the case of the list, how do you decide which ones to admit and which ones don't? You can't just partially explain a list. And the judge even says, fine, find me case law somewhere that says they have to pick and choose 3 or 4 of these to introduce and leave the rest out. And they obviously couldn't. So the second ground for appeal is that the trial court erred in admitting the testimony that Crawford refused to consent to a search of his phone and abused its discretion in declining to grant a mistrial on that basis. I agree that this was a big error that the witness made. But I think granting a mistrial, and I'm going to read you exactly how it happened, but I think granting a mistrial here would have been, as the prosecution phrased it, the nuclear option. And I don't think it's as big of a deal as Bonsip is making it out to be. So when the Prince George's County police officer that executed the search warrant testified. Oh, and another side quest. I heard that this wasn't a knock on the door, we have a warrant kind of warrant execution. This was full SWAT, both doors at the same time.
5 a.m.
5 a.m. And I don't have proof of this, but the person that told me this is apparently closely related to the person that actually was called to repair the doors. So, there you go. And I have to wonder why they did that. Like, were they afraid he had, like, some sort of, like, kill switch to, like, fry all his computers or something? Like, what was the benefit of doing it like a SWAT style? You know he's a cop. He's got a gun. What if he woke up shooting?
You spend that much money and time on training and equipment. You got to deploy it somewhere.
Well, anyway, I thought that was an interesting choice, and I'm sure they have their reasons. I just can't imagine what they were. So this detective testified about seizing the phone, and the prosecution asked him, did you make a request of him, meaning Crawford, about the phone? And the detective says, yes. I asked him for both permission to search the phone and for the passcode to the phone. Now, why did he ask for permission to search the phone if he already had a warrant? He didn't need to ask for that. He just needed to ask for the passcode.
Because getting the passcode would have been a whole lot more difficult. Well,
the prosecution then says they're expecting him to say, yeah, he gave me the passcode. But they asked the detective, and so what did he do? And the detective said, well, he didn't give me permission to search the phone, but he gave me the passcode.
What?
Mm-hmm.
Oh, that's some kind of sneaky insider crap that only a police chief would know or something, right?
I don't know.
Oh. Well, why would you give someone the passcode to your phone, but then specifically not give them permission to look at it?
He has the right to give them not permission to look at it, but they have a warrant, so they're going to look at it anyway.
So why didn't he give them the number, do you think?
Why did he even ask for permission? That's what I want to know. Did
you
have a warrant?
Being cordial, he's trying to establish a rapport. I don't know, but like, why do you think he gave them I guess I'm not a good criminal. I would make it a pain in the ass for you to get into my phone.
Well, the thing that I think is that, remember the list was encoded? And I think he's just a big enough narcissist that he didn't think they'd be smart enough to crack his code.
Oh, man. It's just another thing to smile about and
I think so.
Watch somebody squirm.
I mean, that's a guess on my part.
He just thinks the whole world is a bowl of worms that he watches squirm around. What a douchebag.
So the defense objects. All the parties approach the bench. Now, as I said, it's Crawford's absolute right to refuse a search, as it is your right, as it is my right, as it is everybody else's right. However, the defense moved that this is an incurable error to introduce that the defendant exercised this constitutional right. And so in bench discussions, the judge offered a curative statement, which would be where he would advise the jury that they have to disregard that Crawford didn't consent to this search. But the defense objected to any sort of curative statement, saying that it would just highlight the error more and bring more of the jury's attention to the fact that Crawford refused that search. And instead, he said, the only answer here is a mistrial. We should declare a mistrial right here, be done, we'll try again. The judge denied the motion for a mistrial, but here's what I think. Yes, it was a violation of Crawford's rights. However, I think this really falls apart because I don't think it would have made any difference to the jury. This case had so much compelling evidence that I don't even think that the jury probably remembered that statement, and I don't think it made one iota of difference. And maybe this is because I am into true crime and I do study a lot of cases, but I think people are a lot less prejudicial now than they were years and years ago about refusing searches or refusing to talk to cops without a lawyer. In the past, yes, I think that would have been seen as something more prejudicial, but we're seeing more and more cases where innocent people are being subjected to searches and agreeing to it and then being, paraded through these insane trials. And so I think people are a lot more suspicious of the cops, and I think it's normal now to refuse a search. More so than it was.
With the way that communication is progressing, everyone's sharing information, people becoming more aware of their rights, becoming more aware of the way that those rights are infringed upon sometimes. It's just a matter of course. It's not necessarily law enforcement being malicious all the time. It's just whatever their policies are and the way that they're taught to do things. It's not always correct. And there's people trying to correct a lot of things, and it goes way beyond just law enforcement and the judicial system and everything like that. I think the whole world is, well, not the whole world, but at least a lot of the world is waking up to just a better grip on reality.
Yes. And to me, I don't think if this hadn't have happened, that it would have changed the outcome of the trial. I think it might have been more substantial if the cop had said, no, he refused to let me search his phone, and no, he refused to give me the passcode. But he didn't. He gave him the passcode. And I don't think that this is an incurable error. I don't think that this is something that...
It just sounds like he's trying to put a piece of sand in a big work of cogs. Like you're just trying to mess it up. And I think the judge saw that, and I imagine that I could see the lower parts of the whites of this guy's eyes when he said, no, you're not gonna do that.
I wish I could have seen everyone's faces when he said, well, I moved for a mistrial. I mean, I could hear audible gasps, at the bench. They were and everyone's goes silent for a minute, and then the prosecutor's well, that would definitely be the nuclear option. That's crazy. That's not a big enough... The guy blurted something out. We're not trying to violate his rights. It wasn't an intentional violation of his rights. So I'm predicting that the appellate court will decline to allow a new trial, but I would love to hear your thoughts. You can find us on Instagram, Facebook, and X, and crimetoburn@gmail.com. So as soon as we find out about the appeal, which will probably be around February of 2025, I will bring you the follow-up and let you know what the trial court, or what the appellate court decided. I will also be doing a follow-up on those additional fires that have some very circumstantial ties to Crawford, but I'm going to go ahead and give you a little teaser now. There was a fire at a company called Laurel Fuel Oil, and this company was owned by the Clacoon family, and I really hope I'm saying that right. If I'm not, I apologize, Scott. Now, Scott, who was the son of the man that owned Laurel Fuel Oil, he did reach out to me, and he was the only person in this entire case that has been willing to go on record. Thank you, Scott. So Scott's father sold Richard McLaughlin his house and made him a really good deal on it and may have even helped him with financing it. In addition, there was one incident that Scott told me about that his father had mentioned to him. There was like a teasing kind of incident, nothing outright mean or malicious to most people, that may have been the thing that offended Dave, because not only was this family friends with the McLaughlins, they were friends with the Crawfords. I have requested the investigation report, the fire incident report, and the photos from this fire, and have spoken with the investigators that investigated it. And I want you guys to remember, these things are not free. But I'm going to bring you that update so that you can decide how you feel. And here's the kicker. So that's one additional fire. Fine. But the police, not me, not other people outside of the investigation, but the police tied this fire together with 6 other fires in Laurel. They even have a flyer that I have in my possession that shows the reward that name all 7 of these fires together, because they believed, and they said in a press conference, they believe that these fires are all related. So once I get those reports and the investigation files and the photos from the Laurel fuel oil fire, I will be doing a follow-up and we will cover them. And like I said, there's not enough evidence to definitively tie Crawford to this case, but there are some circumstantial ties similar to the Laurel fuel oil tie, and I will bring them all to you and explain them. Now, as I mentioned, there are fees associated with these records. There are fees associated with the court records, and it's a pretty significant sum, and I'm not asking for any help to offset those costs. I really want to bring you guys a thoroughly researched deep dive case, and all I ask is for you to do something that costs you nothing. Please go and leave us a 5-star rating on every podcast platform that you can, and if the platform allows written reviews, leave one. And you can even leave just a 1 word that says interesting or thrilling, or I don't know, tell me if you like corn dogs. I don't really care. But those 5-star ratings and written reviews go so far in helping us to grow, and if you would be so kind as to open your social media, follow us, give a few of our videos a thumbs up or a heart, and share them with your stories. Tell your inner circle about the podcast. That's the fastest way you can help us grow. And the faster we grow, the faster we will be able to offset the costs of the podcast and these record hunts so that I can keep bringing you these deep dives. And that's really what I want to do. That's what I'm passionate about. We're not asking for donations. We're not starting a Patreon. We just want your support. And also, for those of you asking about merch, which is all of one of you, and I love you, we are in the process of making some merch. We have stickers now, and I've been giving them away as fast as I can. But we will be putting stickers on our merch site, and we are in the process of designing a shirt. So if you are interested in merch, and there's no pressure, I don't want you to think that there's pressure for you to buy merch, but if you're interested in merch, just send me a message and tell me what you want. Do you want hats? Do you want bags? Do you want stickers? Do you want pants? What do you want? Just tell me what you want, and I'll make sure to get it there. We're not trying to make money off merch. We're trying to get merch into your hands so that you can be a walking billboard for us. That's what we want.
You may be giving away the stickers as fast as you can, but if I gave you a sticker, it's pretty special. I'm stingy with the stickers.
I am actually giving away stickers to people that have been sharing our stuff on Instagram and really like pushing us out to their audience. Those are the people that I've been sending stickers to.
I just give them to people who I think are cool.
That's awesome. If you've gotten a sticker,
there's a lot of people that don't have stickers, is what I'm saying.
Yeah, if you've gotten a sticker, you're very special, because what do we order, like, I think 120 of them?
Yeah, not that many.
Not that many. So we will be ordering more, and I will get them on the merch site so that you guys can buy them. But it's just going to take me a little time to get that organized, and I'm more interested in making sure that we don't let the quality of our content suffer and trying to do things like merch. So if it takes me a little while, just please give me a little grace. And I would love to give you a sneak peek of what our next case is going to be, but I honestly have no clue what I'm doing next. I had a case in mind, and I was hoping that I would have court records back from Pennsylvania in time, but it's looking pretty doubtful. Someone had to come up with an interlude. So if you have suggestions, crimetoburn@gmail.com. Please follow us. We do have some fun collaborations coming up, and we'll let you know what those are on our social media and YouTube, so you can follow us there for updates.
What have you brought to disturb me today?
Do you want me just to get into it, or do you want to sit here and chat for a minute?
I don't need any foreplay. Just lube me up and let's rock.
Okay.
What was that?
Jedi.
No, I know this. Don't say anything.
Okay.
No, really, what was it?
It's a Jedi Master of Awkward Silences.
Oh, yeah. I don't know. You have to say a lot of things in a row because it starts making like a frequency.
I'm saying a lot of things in a row really rapidly because that's what I do really well. I like to ramble and I have ADHD and my brain kind of goes off on its own sometimes. Did you know turtles can breathe through their butts?
I think that's better.
Okay. Now for the actual updates we have in this case. I don't know why I said it like that.
I don't either. It's disturbing.
What do you think?
I love lamp.
You were listening, were you?
It's a really strong koozie. It's like getting Excalibur out of that rock. Now I'm king of all England. Oh, you're going to need more than a Viking boat and a couple of hatchets.
All right, so all that we know... I don't want to start with so again. So we know... Did it again. Can I start... How do you start a sentence without so?
Concordantly.
Concordantly.
Ergo. Vis-a-vis.
We've talked about the prosecution's case, so they... Damn it!
You're so cute when you mess it all up.
So adorable. Okay.
Breathe. You must breathe, or the words won't work.
Now, one thing that was noted...
Probably already got hemorrhoids.
I don't want to think about his butt.
Trying to get James Bond to bang you or something.
Okay, sorry.
Say it a different way. Don't include the word box.
Okay.
You said it like a question, though. You said calm like a question. I can't help your terrible dialect. That was technically statement soundy. It was right on the edge, but you nailed it. Yeah.
Oh, don't say that on the air. And instead, he was like, we have to wait for the well pump.
That's exactly what he said. That's a quote.
No, back up. And I really hope I said that right.
There's no way you said that right.
Clacoon.
He sounds like he's going to pop out of a clock or something. You're capable of going on at great length. You're acting like you're doing something wrong. You're being shady.
Well, okay. I'm not being shady. This is not shady. I was going to say something and now I forgot, but it was probably not important.
You just put your lips together and blow.
Like that?
Displacement is not as sensual as actual air. Everyone knows that. I want to get in all the appropriate sort of trauma I can.
I'm not a jerk.
Oh, I am.
Exciting stuff.
Mm-hmm.
Mm-hmm. Mm-hmm. So we are officially signing off of David Crawford for now.